So this kind of new idea that Nixon comes up with, he asks one of his administration lawyers, William Rehnquist, who is later going to become the Chief Justice of the United States. But at that point, he's a lawyer in the Nixon administration. He helps draft this law. He drafts this law for the District of Columbia. And ultimately, it would allow you to detain someone for up to 60 days after they'd been arrested if the government could prove they were substantially likely to win their case on the merits. It was pretty limited because they knew they were testing the constitutional waters because no one thought this was okay. But they made it very limited and narrow. And ultimately, that law it doesn't apply in very many cases because it is hard for the government to win, but it gets upheld in the lower courts. And as soon as it does, and this was Nixon's plan, it gets adopted. Other states say, hey, we should have laws like that. We should also start detaining people pre-trial by claiming that they're dangerous. And so the law that idea spreads, and including at the federal level, Congress passes a law. By the time Congress passes its version, it's like over a decade later, and people had become so desensitized to detaining people pre-trial that by the time Congress passes its version of this, there's no cap on how long you can be detained. There's no requirement that you show you're likely to win on the merits of the case.